Well, in this video we're going to look at collaborative law and what that means and what it entails. Madeleine Young, a senior lawyer here at the firm, is here to explain more about it.
Collaborative law is an alternative dispute resolution process that falls without the court process. It's not arbitration or mediation. It involves both parties appointing a collaboratively trained lawyer who assists them through the process by way of a series of four-way meetings between two parties and their lawyers together to try and reach a solution.
So how exactly does it work? So if a couple came in and you advised them that that would be the route that they would go down, how exactly would it work?
The parties would initially be asked to sign up to something called a participation agreement. That's a document which sets out the parameters by which the collaborative process operates. It explains that the process is confidential. Both parties are expected to be forthcoming in terms of any financial disclosure that's required or information that's needed, and both parties are asked to commit to the process with the view that they won't then be litigating the matter, they won't go to court. So essentially the participation agreement is a contract between the two lawyers and the two parties not to go to court and to try and resolve their differences all together in meetings.
So who would you say it's most suitable for then in that case?
It's most appropriate for parties who want to retain some control over the outcome of their discussions. Within the court process, then if parties can't reach an agreement, then ultimately a judge will impose a decision on them. Within the collaborative process, that if the parties can't agree what the outcome is, then there is nobody to enforce a decision on them. So they retain a far greater control over the terms of their settlement, and they can be far more creative in relation to that. It's particularly appropriate where parties have children together. It enables them to be seen to be working together to reach a resolution, and ultimately that will promote a better relationship for them both in the future in terms of working together for the benefit of their children.
So what would you say the main advantages are then of using collaborative law as opposed to any other option?
Well, it is mostly in relation to the outcome and retaining that control. There is the issue of how quickly matters can be dealt with within the collaborative process. The parties can decide between the pair of them how quickly they want to address matters. If they are keen to get things sorted very quickly, then we can schedule meetings close together. Sometimes for people they prefer to take their time, particularly if they have children going through exams or something like that, then they may wish to delay the matter. So that's definitely an advantage, having that control over how quickly or slowly the process runs. In terms of the cost, it will often be a little bit cheaper than the traditional route, or around about the same.
You mentioned actually within that a participation agreement. What is that exactly?
So this is the contract between the four parties, which sets out how the process will run, and it sets out what will happen if the process breaks down as well. So if there are any concerns throughout the process that perhaps, for example, somebody isn't being very forthcoming about their disclosure, or somebody feels if there's an imbalance of power between the parties, also if there is any suggestion of financial irregularity or the welfare of a child is an issue, then one party or one of the lawyers may express concerns that the process is broken down, in which case the participation agreement provides for what should happen. There will be a sort of cooling off period of 14 days if somebody says that they feel that the process is broken down, to enable everybody to see whether it's possible to recover the process, and if not, then the parties are free to go and instruct new lawyers and take the matter to court if that's what needs to happen.
So what happens, so all being well, the collaborative law process has you've done everything that needs to be done. What happens after it's concluded?
So once the parties have reached an agreement, then the lawyers will do whatever documentation and paperwork is necessary to put that agreement into effect. So if there are divorce proceedings, then it's likely to be a consent order in relation to financial arrangements. In terms of cohabiting couples, it may be dealing with the property issues between them. And if it's in relation to children, then again, if the parties have decided that they want a court order, then the lawyers would draw that up and deal with that process from there on in.